I'm Angel Cook, and I'm here to speak on behalf of the bill, for the bill, sorry. And I speak on behalf of myself and a dear friend of mine named Anita Tutt. On September 14, 2002, a baby boy was born. He was 27 weeks, 1 pound, 3 ounce preemie. This baby boy was not expected to live. He had a bowel obstruction, incarcerated left inguinal hernia, a small bowel resection, respiratory distress, chronic lung disease, a heart murmur, sepsis, pneumonia, anemia, thrombocytopenia, renal failure, hypothyroidism, and retinopathy. With all these life-threatening issues, this tiny baby boy and his family fought for his life, and they never gave up. His mommy sat at his NICU bed each and every single day, reading to him and praying for a miracle. She went days without sleep and cried endlessly. She agonized over seeing her son barely holding on to life as his body was struggling for every last breath. Over 4.5 months in the hospital, she learned the ins and outs of what her future now held with being a mother to a medical fragile child. Her entire life now revolved around weekly specialists that was determined from the hospital that her child needed in order to survive. Over the next 13 years, this young boy continued to live with 23 complex chronic medical conditions diagnosed by medical professionals, including congenital heart disease, chromosomal abnormalities, aortic valve disorder, negative bone density, and so much more. She helped him 24 hours a day, 7 days a week, and 365 days of the year. Sadly, in 2016, doctors lost all hope. On March 4th, a doctor signed an out-of-order hospital DNR. On the 8th, they placed him solely on TPN feedings, and on the 18th, a physician certification of terminal illness was signed by 2 doctors certifying that he was terminally ill and that he had 6 months or less to live. In this child's medical records, his physician wrote that the parents' decision to agree to a DNR order was an extraordinary, selfless act of love. This mother's whole world fell apart. Her baby boy was dying after a doctor said there was nothing left for them to do. She questioned why God would allow this after all that her son had been through. She prayed and she felt God telling her that it's not over, so this mother spoke up and she reached out for a second opinion. Sadly, little did she know that that call would ultimately cost her and her family their entire life. The very second she questioned her son's care, a call to CPS was made by medical professionals who were involved in her son's treatment. Throughout the CPS case, his mother asked for a second opinion, but CPS refused and chose to consult with the doctors at the very hospital this mother was questioning their care. Luckily, the mother's parents were successful in gaining custody and they sought a second opinion. The doctors at this clinic sided with the mom and confirmed that this mother was not medically abusing her son and that he was in fact sick and had a medical condition called Ehlers-Danlos syndrome that was missed by the original hospital and that he was not terminally ill like the previous doctors suggested. CPS dropped the case, but it was too late. They had already petitioned for criminal prosecution, and this mother currently sits behind bars today while her son cries himself to sleep, longing to see his mommy again, not understanding how the one person who fought the hardest to keep him alive all these years is no longer able to tuck him in at night. House Bill 2134 has the power to not only protect medical fragile children and their parents like this mother and like myself, but it also has the capability to help overworked, underpaid caseworkers who are stuck in the middle between parents and medical professionals who are in disagreement about the care of a child. It holds the power to prevent incarceration of innocent parents, the capability to prevent wasted civil court time, appeals, CPS sanctions, lawsuits, and the financial hardships already placed on families of children with special needs. Last session was a huge step for families like mine with the passing of House Bill 2848, but it did not go far enough as this agency found a loophole that ultimately allowed them to go around what this bill was intended to do. But with your help, we can fix this and help medical fragile children in the process. Help us protect the very children that God personally chose us to protect. Thank you.
Okay. Thank you very much for your testimony. Members, any questions? Okay. Thank you. Jeremy, if you know the drill.
Members, my name is Jeremy Newman. I'm the Policy Director with the Texas Homeschool Coalition, and I'm here speaking in favor of the bill. And our interest in this really comes from 2 main issues. Most of the committee, I'm sure, knows this, but we get involved in more than education issues. It really anything that deals with the right of families to raise their children falls under our mission. And so ideologically, we have an interest in that. And then practically, one of the things that we offer to our members is representation in CPS cases. And so over the last for years, we've had about 50 of those cases that we've dealt with. And so as a result of that, we kind of have a network of families and attorneys around the state that we've communicated with on these types of issues. And this type of story is one that I've heard numerous times. And so I obviously cannot offer anything to you more compelling than the personal stories that you've heard. And so what I really want to underscore for the committee is the importance of considering, in addition to the trauma that we obviously consider when we're trying to remove a child and what we're trying to protect them from, we have to consider the trauma that is caused by a removal if we do it incorrectly and if we do it too hastily and if we don't have some basic protections in there to ensure that only the right children are being removed, then we can end up being the source of trauma to that family instead of the thing that protects them from that trauma. And so I think that these types of protections are really common sense, basic things that make sense for us to implement in order to protect families from the types of things that you've heard here so far. So if the committee has any questions, I'm happy to answer them.
No, I appreciate that testimony. I think I think you're right. I think that the challenge is, I guess, every newspaper story, everything is always the tragic things that happens if you don't take them, forgetting that every time you remove a child, you cause trauma. Sometimes that's necessary, but it is, and really the due process, it's funny, we talked about due process in some fairly small areas with licensing and other things in other committees, and we're talking about some reasonably due process in whether or not your child is going to be removed from you. You know what I mean? And whether or not your child, so thank you very much. Appreciate your testimony. Members, any other questions? All right, thank you.